Well, good afternoon. Okay, guys, the fun light is on, right? We're all having fun? Okay. Well, yesterday you saw that killer demonstration of direct and cross, and today, just in time, because tomorrow you're going to be doing your opening statements, you're going to see two incredible trial practitioners, two incredible trial lawyers, once again present their craft. And they asked me to talk with you a little bit about what you're going to see so you can look for it in advance. And so as they're doing it, you can go, oh, that's what they're doing. But before we get there, I was talking with Professor Zweer, and he was sharing with me some of the experiences that you guys have had over the course of the semester. And specifically that presentation that you made, that objective presentation to the client that you had to make earlier in the semester. Well, you know, an opening statement is a lot like that because it's about the facts. It's not so much about argument. In fact, it's actually not about argument. And to the extent that there are any objections, although I'll be sitting down there, I'll be prepared to rule on those objections
You can sit here,
in an
Judge.
appropriate manner. But Professor Zweer asked me to remind you, and on behalf of your faculty, I also want to remind you that, you know, there's an incredible amount of information that relates to opening statement right here in the book that each of you has. And we commend it to your consideration as you prepare for your exercises tomorrow. Now, let's get with what we're going to be doing today. Let's talk about what you're going to be seeing, and specifically some of the things that you're going to be seeing today that are a little bit different than your standard opening statement. Because this case, well, this is a little bit of a weird case. You have a national celebrity right here. Okay? This.
Oh, no.
And that creates some fascinating challenges for the prosecution and for the defense. And so when you're watching the prosecution's opening statement, she's going to do something that you normally would not see in your standard opening statement. She's going to talk about the fact that she's dealing with a celebrity. She's going to talk about some of the issues that surround that. And of course, that's not something that you would normally see. You're also going to see her, and look for this. It's not that she's going to use the law. She's not going to argue the law, but what you're going to see here, because it's a requirement of the prosecution, she's going to lay out what the elements of the crime are and show you what the facts are that relate to those elements. And so as part of her presentation, look for that, because the prosecution, if they don't, in their opening statement, lay out sufficient facts on every element, and she's going to lay that out for you, if the prosecution doesn't do that in any case, if the facts aren't there to support every element within that opening statement, then the defense can actually move at the close of the prosecution's opening statement for a dismissal. And so you're going to see that. You're also, interestingly enough, you're going to see something, again, in this case, a stylistic difference between how the two lawyers work with visuals. And look for that stylistic difference because it's tactical. And we're going to be talking in your small sections tomorrow about the reason why that is tactical. Now, with respect to the defense, here's a couple of things to think about, because Bob and I were talking about this, and he says, you know, Matt, I don't want to overpromise, because if I overpromise and I can't deliver, then I may have a problem a little bit later. So look for the fact that he's not overpromising. Look for a clearly defined theme. Something that resonates, that speaks to the gut, something that is clear from the get-go. And the very last thing that I want to leave you with, because you will remember the very first thing I said to you, remember that was about whether or not we're having fun, you will also remember the last thing that I say to you, and you will remember the first and last things that the advocates say. Think about primacy and recency. How each of them uses the structure of the argument to have a clear thematic statement at the beginning and a clear thematic statement at the end. And with that, ladies and gentlemen of the jury, I ask that you give your attention to counsel for the prosecution's opening statement.
Thank you, Your Honor. You can have your bench if you like. May it please the court. Good afternoon, counsel, and members of the jury. Good afternoon. Greed, cheating, and lying. That is the mantra of Hollywood's Wall Street. You remember the movie, Greed is Good. That is the mantra, the motivator of the defendant in this case, Nancy Vansusdam, and her good friend and stockbroker, Frank Butchko. The two of them, motivated by greed, sold 3,928 shares of the defendant's stock unlawfully. And not only did they do that, but then when the federal government, the agents that are charged with the responsibility to police the stock market, were alerted to the irregularity in the transaction, and they were nipping at their heels, they had to make an adjustment. And the evidence will show that the adjustment that they made was a conspiracy and a plan to make up an excuse for why that stock sale occurred on the day that it did. And I'm going to explain that to you. The result of that sale and the investigation is why the defendant is sitting here today. She is charged with one count of making false statements to a government agency. Before I continue with the presentation of evidence, I want to take a step back. My trial partner, Matt McCoy, and I have the privilege of representing the people of the United States of America in this case. And during jury selection, we talked to you about the uniqueness of this type of defendant. We talked to you about her celebrity status. And during jury selection, you assured us that you would set that aside and that you would judge this case only on the law and the evidence. And as I go through what the evidence will be in this case and the evidence that we will bring to you so that you can determine and find the defendant guilty as charged, remember that assurance that you gave during jury selection. Now, this case begins with another stock sale involving a different company, a company called Kin Life. Kin Life is a biopharmaceutical company, and they're held primarily by a family, the Kinloch family, and friends and business associates own the majority or a bulk of the publicly held stock in this biopharmaceutical company. In the fall of 2012, Kin Life was on the cusp of releasing a brand new cancer drug. This cancer drug, there was a lot of buzz about it, a lot of publicity about the release of this drug, and it was highly anticipated. Before the drug could be released, the drug needed FDA approval. Before this drug could make money for the Kin Life Corporation, it needed FDA approval. It's critical for the company. The Kinlife company presented their application to the FDA for approval on October 31st of 2012. The FDA, by law, must turn around that application and return with an answer to the company within 60 days. That meant that towards the end of December, the Kinlife company and the Kinlock family would have their answer. Now, the Kinlock family was not a stranger to this defendant. She knew this family. In fact, she owned Kinlock shares, Kinlife shares, about 5 or 8 years before the subject transactions that were here. She owned about 928 shares of that stock. You will learn throughout the course of this case that on October 31st, the defendant was at a party with the principals, some of the corporate heads of Kinlife, and she learned that the company was going to be seeking FDA approval. That party was October 31st, 2012. Now, the defendant's own corporate records, which you will see, show, not corporate records, excuse me, stock portfolio records. You will see that in October 2012, she purchased 3,000 additional shares of Kinlife stock. Kinlife submitted their application to the FDA October 31st, 2012. The same day she had the conversation at the party with the principals of that company. Now, fast forward. December 26, 2012. We're close to that 60-day mark. Something critical happens. William Kinlock, the CEO of the biopharmaceutical company Kinlife, receives a tip. The FDA is not going to approve that cancer drug. That means that drug, for the time being, was worthless, a draw on that company. And as a result, the Kinlock family decided they needed to dump their stock, and quick. The next business day, December 27th, early in the morning at 8:30, the Kinlock family places a call to their stockbroker. Their stockbroker is none other than Frank Butchko, the same stockbroker that is friends with the defendant, the same stockbroker that handles her portfolio. They tell him, sell, 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 all of it. Over $7 million worth of stock from their family, their friends, and their business associates. They ask, of course, for Frank Butchko, and instead, Frank's assistant, Miss Farrell, Deborah Farrell, answers. She's also licensed to sell stock. She says, he's on vacation. It is imperative that you sell immediately, all of it. Miss Farrell calls her boss, who's on vacation. He says, sell it. Oh, and by the way, call my friend, Nancy Vansusdam, and let her know. And so, like a dutiful assistant, she does that. She places a call to the defendant's office, speaks to her assistant, Miss Anderson, because the defendant is on an airplane herself and can't be reached. Later on that afternoon, after some phone tag and calls between offices, the defendant does call in and speaks to Miss Farrell. And Miss Farrell lets her know that the Kinlocks are dumping. They're selling their stock. The defendant says, do the same. And by the way, what's that stock selling at now? Ms. Farrell says it's selling at $58 a share. That's an important point, and we'll come back to that. Throughout the day, the Kinloch stock, or the Kinlife stock, continues to drop in price as the day proceeds because the FDA, that very same day on the 27th, they do announce publicly later in the afternoon that they are not licensing the cancer drug. So, by selling when the defendant did, before the information became public, she did not lose $45,000 that she would have lost otherwise. By the next business day, she would have lost $55,000 as a result of the plummeting stock. So let's talk briefly about these transactions and what is insider trading. Insider trading is against the law, is what it is. And it's when someone in possession of non-public material information purchases or sells stocks or securities or recommends another to buy or sell. It's unlawful. The other thing that's unlawful is something called piggybacking. And piggybacking is buying or selling securities after a client bought or sold the same security to take advantage of the client's knowledge and expertise. Frank Butchko, as a stockbroker and as an employee of the Cato investing brokerage firm, he knew that what he did in piggybacking off the Kinloch sale with his friend and telling her so that she could sell, he knew that that was unlawful. But, members of the jury, keep in mind, the defendant is not just a celebrity, a salacious character on television that we've all seen. She's a lawyer. Don't forget that. She was a prosecutor. She had my job. She was a lawyer for 10 years. And when she left her job as a prosecutor, she was employed as in a law firm that specialized in securities, in stocks. And so she advised clients on securities law. She teaches at a law school. Law students. Impressionable people. She teaches them securities law. She's on the board of a securities stock exchange. I submit to you that she knows the law, she knew what she was doing was wrong, and we will prove that to you throughout the trial. Insider trading is wrong, members of the jury. You will hear from the lead investigator in this case and from industry standards. Insider trading threatens the economy of the country, threatens the stability of the entire country. People invest in the stock market because they feel they have a fair shot. If the average person feels they cannot invest their pension and their money, that hard-earned money, in the stock market, businesses will not flourish, our economy will fail, the market will crash. That is why these crimes exist, and that is why the agencies that investigate these crimes do what they do. So, there is a federal agency whose job is to monitor suspicious or large stock sales that happen in advance of a key event. So in this particular case, that FDA approval that everybody was waiting for was that key event. So this agency's job is to have hindsight. And when a key event occurs, And there's a very suspicious series of trades before that event. They report it. And so in this case, that agency, that monitoring agency, reported the Kinloch $7 million sales and the defendant's sales to the SEC and the FBI, who are charged with the responsibility to investigate these types of cases. And they started to make phone calls and inquiries. And when they started to call the defendant, her stockbroker, the assistants, and the other people in the office, that triggered something. Uh-oh. We've got to do something to cover up what we did on December 27th. The solution, a stop order at $60. A stop order at $60 that they told the government investigators they put into place sometime in December. The date is unclear from the defense point of view. And what that means is the defendant wants you to believe that it was a coincidence that she sold all her stocks on the same day that the Kinlochs sold theirs, and that she had a pre-existing order with her stockbroker to do so. The evidence in this case, I'm going to outline for you as briefly as I can in the limited time that the judge has given me, shows that the pre-stop order at 60 is not supported by the evidence. The defendant and her broker made multiple conflicting statements about when, how that stop order was authorized. And you will see and hear all the conflicts in the evidence throughout the trial. There are many conflicting statements about December 27th. Who called who spoke to who said what to who. When you hear the conflicts, it will be evident to you that those are lies. Butchko, Frank Butchko's own secretary, confirms that she told the defendant that the Kinlochs were dumping. She will also testify that the defendant ordered her to sell after learning about the Kinloch sales. The defendant's own secretary also received a call. Everybody was playing phone tag that day. You remember, Frank Butchko was on vacation. The defendant was traveling. So the assistants were taking messages. In the defendant's secretary, Ms. Anderson's own logbook, you will see the following entry. Frank Butchko thinks Kinlife, trading downward. The defendant initially didn't like that. That's damning. That's the tip. That's the non-public information. That's the piggybacking. She didn't like that. So what she did is she deleted it from the phone log. But then, she's a smart woman. She realized, I can't do that. The FBI has asked me to disclose documents to them. I can't disclose this document after I deleted information. So she puts it back. But that is evidence of knowing that what she did with Frank was wrong and unlawful. Blue sheets. Blue sheets are an industry term, which we will show you what they mean and show you how they were used. Blue sheets are issued by brokerage houses, and they document a stock sale transaction. And there's certain criteria and information that is included on these blue sheets. One of the lines indicates whether or not the stock was sold pursuant to a preset stop order. Remember, the defendant's reason why she sold on the 27th was because she had a preset stop order at $60. It's not noted on this official blue sheet from the brokerage house. Members of the jury, there are no phone records to support the defendant and Frank Butchko's alleged calls in December when they were doing business to set up this stop order at 60. There are no phone records to show that. And the defendant's own memory of the day when she created, allegedly, the stop order, well, she forgot about that when she was interviewed initially by the investigators. But that's okay because her memory was refreshed by her stockbroker, Frank Bacchio, at breakfast. And he used a document to refresh her memory. And the document shows that she had purchased 3,000 shares of Kin Life stock in December, but we hired an expert to look at that document. And the expert analyzed the ink forensically, and the expert will testify that the ink on the entry that says stop at 60 was done much later, weeks later, 5 weeks later, than from the December 2nd purchase date of the stock, putting that at 60 mark into January, way after December 27th. Members of the jury, we have to prove this case to you beyond a reasonable doubt. And the crime, again, is making false statements. And the elements that we must prove, each and every one of these elements, are that the defendant knowingly, voluntarily, and intentionally made false statements regarding a security matter. The security matter is proven. Knowingly, I just went through the evidence explaining knowingly. Voluntarily, there was no waterboarding here. And intentionally, there was no mistake. The third element is within the jurisdiction of the government agency in question. That's proven as well. Clearly, the SEC and the FBI have jurisdiction. So were the false acts and the lies material? The actions in creating the fake paperwork to document a pre-existing order to sell on the 27th instead of selling as a result of piggybacking, is that material? The law says that something is material if the statement has a natural tendency to influence or is capable of influencing the decision agency. That fabrication of a stop at 60 was intended, okay, my judge gave me some extra time, so whoever's doing that is wrong. And to close, thank you, Your Honor. I appreciate your generosity. And to close, clearly the lies were made to influence the decision-making agency. For these reasons, members of the jury, we are confident that when you hear all the evidence in the case, you will find that we've proven this case to you beyond and to the exclusion of every reasonable doubt, and you will find the defendant guilty as charged. Thank you, Your Honor.
Pardon me?
Please give your attention to counsel for the defense opening statement.
May it please the court. This is a case about what Nancy Vansusdam knew and when she knew it. Plain and simple. Let me be more specific. There's a $60 stop order in place on Kin Life shares. More specifically, this case is about what Nancy Vansusdam knew on December 27, 2012, between 11 a.m. and 1:52 p.m., a 2-hour and 52-minute time frame based on one telephone call. One telephone call that she took while she was at an airport in Texas on her way to another flight to go to Mexico. And the reason that I say it's that simple is because when we separate the clutter and the hyperbole here, when we really look at the results of the investigation counsel told us about, the evidence will show that 2 months ago, on February 27, 2014, the court dismissed all securities fraud charges against Nancy Vansusdam. All we're left now is to talk about a 2-hour and 52-minute period of time on December 27th and what Nancy Vansusdam knew because of one telephone call. Let me introduce you to Nancy Vansusdam. Nancy Vansusdam graduated from law school in the 70s, Emory Law School, and shortly thereafter took a job in a securities firm, securities law firm, and she did very well there. She worked at the securities law firm, and the Emory Stock Exchange contacted Nancy, and they asked her if she would like to be a member of the Emory Stock Exchange. And she accepted that invitation. Nancy Vansusdam worked on the board of the Emory Stock Exchange for a period of time, and then she caught the attention of the Emory News Agency. The Emory News Agency said, you know, Nancy, what we'd like to try to do is an experiment. We would like to have you do a media thing. We'd like to put you on TV to talk about the law and to talk about securities and to talk about some of these things. And Nancy Vansusdam did that. She accepted that invitation. Guess what? It was phenomenally successful. And her media career zoomed from there. Because as a result of that first program she did, Nancy Vansusdam now writes 4 articles in the media. She's on 4 TV segments on Fox News. Nancy Vansusdam owns her own media company. Nancy Vansusdam has even wrote a very significant and very popular book. And now she sits here today not because of what Kinlock did, Cato Investing, Frank Butchko, Deborah Farrell, and all that other stuff. She sits here because of what she knew through one phone call. Because you see, on December 27th, 2012, Frank Butchko went on vacation. Frank Butchko went to Florida on vacation. At the same time, Nancy Vansusdam was on her way to Mexico to go on vacation. This $60 informal stop order was triggered on Kinlock stock. What is the evidence going to show you about the Kinlock stock? And what is the evidence not going to be about Kinlock? Kinlife is the company, Kinlock is the family. In the year 2005, Nancy Vansusdam purchased her first shares in Kinlife stock. For the next 7 years, the stock basically did nothing. Those of you who own stock know that what you try to do is buy low and sell high. Well, this stock was doing nothing. She bought it at $72 a share, and over the course of 7 years, it had lost money to the point where it was in the 60s. And so Nancy Vansusdam and her stockbroker, Frank Butchko, decided to do an informal stock order that if those shares hit $60 a share, sell. Now we know that this is a period of time between 11 and 152 because of the 1352 time frame, that's 152 Eastern Standard Time, when Deborah Farrell, lady at the bottom, placed the sell order for Nancy Vansusdam's 3,928 shares. So we know that's the end date on the facts that are relevant in this case because that's when the shares were sold. We'll learn more about Deborah Farrell later, but for the time being, what you need to know is that her boss, by the way, she was sleeping with the boss, and that evidence will come out too, and we'll talk about that at some point. But her boss had what's called an investment planning log, and you'll see just a little bit below halfway that the Kinlife shares have an informal stop order agreement at $60 a share. So that is going to be the evidence here with respect to that stop order, 1:32 p.m. being the end date, and 11 a.m. being the start date, because that's when Deborah Farrell started trying to get a hold of Nancy Vansusdam. They couldn't get a hold of her because she was flying. She was in the air till she got to Texas. Nancy's secretary got a hold of her, said that we need to talk. Between flights, they talked. The stock is going down. And so, as we saw, that was sold at $58 a share. There is clutter, and there is hyperbole here. But I'm going to tell you something about what the evidence is also not going to show. Nancy Vansusdam was never a member of the Kinlife Board of Directors. She was never a member of the management team at Kinlife. She was never an employee of Cato Investment Company. Nancy Vansusdam knew nothing on December 27th about any cancer drug that might be going south. Nancy Vansusdam knew nothing from any conversation with anybody from the Kinloch family because she hadn't talked to anybody from the Kinloch family for months. What Nancy Vansusdam knew, and the evidence will show, is that she had an informal stop order to sell her shares at $60 a share when the stock started to go down. And in one telephone conversation on December 27th, while she was between planes, they told her stock was going down, and she said, when it gets to 60, sell. That's it. Now, at the end of this case, we're going to have another opportunity to talk to you. And at that time, we're going to tell you how the facts and the law apply to a government case that isn't even tissue paper thin. And at that time, we're going to ask you for a verdict of not guilty on behalf of Nancy Vansusdam. Thank you.
Isn't it a joy to see two great advocates? Think about what you saw, clear themes, trilogies. Think about the use of visuals and the different uses. Have a great evening.